The World Trade Organization is the only international organization dealing with the rules of trade between nations. It is fully based on agreements which have been negotiated and ratified by a large number of countries taking part of the global market. About the internal structure, we could say that the World Trade Organization is actually run by its member governments, but the activities are coordinated by a secretariat, which ensures that negotiations progress smoothly and that the rules of international trade are correctly applied. As I said, major decisions, though, are made by the memberships as a whole, either by ministers, who meet at least once every 2 years, or by their delegates, who meet regularly in Geneva. Basically, World Trade Organization spells out the principle of liberalization, and it stands for trade negotiation between countries by implementing transparent agreements and periodically monitored policies. However, the agreements also contain special provisions for developing countries, such as longer periods to implement commitments, measures to increase their trade opportunities, or support to help them with trade capacity. Furthermore, it tries to enhance cooperation and increase awareness of World Trade Organization activities by maintaining regular dialogue with other organizations. Also, it settles a procedure for resolving disputes, enforcing the rules, and therefore ensuring that trade flows smoothly.
Onto the World Trade Organization dispute settlement system. First of all, it is important to highlight that a dispute arises when one country adopts a trade policy measure or takes some action that one or more fellow World Trade Organization members considers to be breaking the World Trade Organization agreements or to be a failure to live up to obligations. Dispute settlement is the central pillar of the multilateral trading system and the World Trade Organization's unique contribution to the stability of the global economy. The World Trade Organization's procedure underscores the rule of law, and it makes the trading system more secure and predictable, since it is based on clearly defined rules, with timetables for completing a case. The current disputed settlement system was created as part of the World Trade Organization agreement during the Uruguay Round, and applies to all disputes brought under the World Trade Organization agreements to those states which belong to the organization. The rules of the dispute settlement system are established in the Dispute Settlement Understanding, known as DSU. The functions of the dispute settlement system are, inter alia, providing security and predictability to the multilateral trading system, preserving the rights and obligations of World Trade Organization members, clarification of rights and obligations through interpretation, and so on. The only participants in the dispute settlement system are the member governments of the World Trade Organization, which can take part either as parties or as third parties, the World Trade Organization Secretariat, and the World Trade Organization observer countries. Neither local and regional governments nor individuals are companies. Finally, it is important to highlight that neither local and regional governments nor individuals or companies are entitled to initiate dispute settlement proceedings in the World Trade Organization.
Now, we're going to talk about how are the disputes settled. Settling disputes is the responsibility of the dispute settlement body, which consists of all WTO members. First of all, the countries in dispute have to talk to each other to see if they can settle their difference by themselves. If that fails, they're going to reach the second stage, the panel. The country in the dock can block the creation of a panel once, but when the dispute settlement body meets for a second time, the appointment can no longer be blocked. The fact is that the panel's report can only be rejected by consensus in the dispute settlement body. Its conclusions are difficult to return. The panel's final report should normally be given to the parties to the dispute within 6 months. In cases of urgency, including those concerning perishable goods, the deadline is shortened to 3 months. Finally, a report is submitted to the two sides, and 3 weeks later, it is circulated to all WTO members. And it will become a ruling or recommendation within 60 days unless a consensus rejects it. Either side can appeal a panel's ruling. Sometimes both sides do so. Appeals have to be based on point of law such as legal interpretation. Finally, the dispute settlement body has to accept or reject the appeals report within 30 days, and rejection is only possible by consensus.
Now we will specifically talk about the case of United States versus Antigua and Barbuda in the year of 2013, a case which was finally resolved in the year of 2013. As a general overview, the grounds of conflict presented in this case was the fact that the United States decided to prohibit any form of gambling and betting services that were provided online by other countries. In the year of 2003, Antigua and Barbuda presents in the World Trade Organization a demand against the United States' decision of not allowing cross-border supply of gambling and betting services. They argue that the decision goes against the general agreements of trade and tariffs. This was a very significant decision for Antigua and Barbuda due to economic and ethical reasons. In an attempt to diversify their economy, they invested greatly in telecommunication services, as well as in an attempt to involve the youth in different markets. They invested in a lot of education for this technological advancements to occur in a country such as Antigua and Barbuda. And finally, the United States declares that they decided to make this decision, and the reason to why they reached the decision was due to financial and social risk. To this, the panel presented its resolutions, in which it states that as the United States is part of the General Agreements on Trades, then the World Trade Organization does have jurisdiction over the issue of gambling and betting. Furthermore, they state that the United States is not discriminating against Antigua. Their federal law just goes against the laws of the General Agreements on Trade. Antigua and Barbuda did not fundamentally justify their claims, is another statement that the panel makes. The United States attempts to argument that the given circumstances allowed for a legal exception, but the panel refuses this and states that this is not the case. Finally, the case is resolved through the appellate body resolution, where they state that the panel should have abstained its ruling on the 8 state laws of the United States, which Antigua and Barbuda had not made a claim against. They supported the panel's resolution that the United States should maintain its borders open in regards to gambling and betting services online. And it furthermore upholds the panel's decision that the United States acted against the General Agreement on Trade. And it finally states that the United States had proven how these 3 acts are necessary in order to maintain public order.
In order to implement the resolutions adopted by the panel, United States required time to adapt their legislation. An independent arbitrator established that the corresponding period of time was 11 months and 2 weeks. However, once this time was over, Antigua and Barbuda was not certain that the United States had complied with their resolutions. Because of that, they invoked the Article 22, the article that established possible sanctions to members that don't fulfill with their obligations. Antigua and Barbuda asked for the suspension of concessions to United States. The arbitrator sided with Antigua and Barbuda, but United States still did not comply with the resolution. In conclusion, this is a good example of soft law because there is no legally binding force applied to US for their violations against the GATS.